This meeting is being recorded.
Good morning and welcome back to the Committee on the Revision of the Penal Code. I'm going to give a few minutes so that people can populate the Zoom room. All right. Good morning. This is a meeting on the continued meeting on the Committee on the Revision of the Penal Code. Here's our agenda for today. We had a great meeting yesterday. I really do, again, appreciate the staff, all of the witnesses who came and spoke. It was a record for us. As Justice Moreno noted, 22 witnesses, I think, we heard from, which was really a staggering amount with a great deal of information. So we're going to now discuss what we heard yesterday to refine recommendations that will go into our 2022 report for in the bail context. We have some slides on that we'll walk through in a second. And then Tom will take over and we will review the proposals and recommendations that we have from prior meetings earlier this year. The third step is we will have a public comment and then we will vote to adopt those recommendations or not. Do anybody have any questions about the procedures or agenda?
Nope.
All right. And as usual, we'll take breaks as needed along the way. Anybody who needs a break, please let me know and we'll do that. But we had a long day yesterday. I think it was very productive. And I think today will be much shorter and hopefully equally productive. All right. So Tom, do you have a slide? Okay. So are you fully sharing your screen, Tom?
Yeah, is that good? Can everybody?
Yeah, we see it.
Sure.
Be bigger?
Yeah, we see your screen. Yeah, there we go. I think that's a little bit better. All right, so this is a discussion of the bail and pretrial proposals. This includes everything from cite and release to Humphrey to probable cause determinations. That's everything that we discussed yesterday. We have a quick table of contents as to, I tried to organize the ideas that came up yesterday in some kind of sense. Tom, Joy and I this morning worked on this. So obviously, if there are other ideas that come up, please let us know or jump in. But this is primarily a way to organize our thinking and follows to a large degree the proposed recommendations that are in the committee memo. So starting with number 1 on cash bail reform. So this is, again, primarily focused on at the time period prior to arraignment. So all of the Humphrey concerns we're going to talk about in a later slide. And the two main recommendations that I could see that came up yesterday are to set a statewide bail schedule and to create a way for the court to accept a promise to pay or some kind of unsecured or partially secured bonds is the terms of art. To get to the bail schedule issue, I have actually mixed feelings about this, but I think in the end, I think that a statewide bail schedule should be set and should probably be set by Judicial Counsel. Here's the way it currently works. Each county has its own bail schedule. Immediately upon your arrest, even prior to any arraignment, if you can meet that bail schedule, it essentially means meeting with a private bail bondsman and paying 10% of whatever is on the schedule. And the schedule corresponds to whatever crime you're charged with. It has nothing to do with ability to pay. It has nothing to do with your flight risk. It has nothing to do with your future threat to public safety. It only corresponds to whatever you're arrested with. And if you can make that bail schedule literally within hours of your arrest, you're released. The advantage, obviously, is that it can happen very quickly, quicker than any court could act. The disadvantages are what I discussed before: ability to pay, threat to public safety, threat to flight risks are not accounted for. And of course, that there's a statewide disparity. It's problematic. We heard, though, yesterday, of course, the different counties probably have different abilities to pay. So to kick things off, I would suggest a recommendation that says that Judicial Counsel should set a statewide bail schedule with ranges, perhaps that are tied to median income of the county. I'm not quite sure how to do it. It's imperfect, but that would be my suggestion. So does anybody have any thoughts about bail schedule? Yeah, Senator Skinner.
Well, we did hear from speakers who recommended against a bail schedule. We had a lot of information presented yesterday, so it was a bit overwhelming for me in terms of trying to digest it all. And I would like to have a little more information regarding those who recommended against it and had real issues with it. Why? That's one issue. And then obviously it just assumes, or I know that you have a second proposal, but it partly assumes that there needs to be bail in most cases. And I think part of what we were hearing from folks is that there's a lot of circumstances where we probably should not even be utilizing it. So I'm not sure yet about that being one of our core proposals.
I have thoughts, but I want to hear from other folks about that.
Yeah, I agree, Michael, with your basic proposition, but maybe it should be with the caveat that, like if it's a misdemeanor, if there's a presumption applies that the custodial officials really would first look at, these presumptions, and then if they do set bail, then that would apply. And that might eliminate, address a lot of the criticisms we have with respect to bail and maybe some of Nancy's concerns. If the presumptions are strong, that in most instances it's going to be just a cite and release.
Yes, so
Or release from the police station, after booking, whatever.
yeah, I agree with that. And actually, we had that as a separated out proposal. So maybe that they should be thought of as combined.
Yeah.
So we did hear that in most arrests in other states, and actually a large number of arrests in California, because so many arrests are misdemeanors, are subject to some kind of cite and release or administrative release, or there's different terms of art. So I do think, and I think that we should make a recommendation to expand and clarify what are administratively, I'm going to prefer the term administrative release, because some of those things can be done and determined by the officer in the field. For example, if it's a very low level crime that someone's being arrested for. But I think that there are other circumstances, maybe a little bit more serious felonies, but with no prior record, for example, or no prior missed court appointments, that might be able to be done at the police station administratively. Right. But there's still going to be, for violent felonies, I think unavoidable that we have some sort of pretrial detention and a determination. And the advantage of having a bail schedule is that at least some people can immediately bail themselves out. Now, maybe we should just prohibit that altogether, but otherwise people are waiting 48 hours to see a judge.
Well, bail only comes into consideration if the person is in custody at the jail.
Correct.
So, I think that after booking, many people are released. The cops just want to have a record of the arrest, maybe a photograph, give the booking information. But then the decision is made, okay, you're released OR, you're going to be cited, back to court. So at bail,
in Los Angeles County, I don't know what it's like in the rest of the state.
Yeah.
We have a jail overcrowding problem in LA, so misdemeanors aren't generally held.
Yeah.
They're not put in the county jail unless it's a DV or a drunk driving with priors situation. Yeah. But I don't know what it's like in the rural counties where they don't have jail overcrowding issues. I mean, I would prefer a recommendation that there be a presumption of release on misdemeanors, with an exception for those two categories. Yeah. And there was some conversation yesterday about including non-serious, non-violent felonies in that presumption. And I'd like us to consider that.
Yeah.
Yeah, and I think this is bleeding into the cite and release or administrative release discussion. So maybe I'll let it go there. Here's the problem with, or here is the data, at least that we have so far. is that in many counties, there's a lot of cite and release. So according to data that we have, for example, in Ventura County, it looks like most arrestees are cited and released. Now, it might just be in Ventura County, they arrest more misdemeanants than in San Joaquin Valley County, for example, which has very few cite and releases. It may be that they're not exercising their discretion properly. We need to look at the statute, or that just police are arresting fewer misdemeanants in San Joaquin County. But it does seem like the cite and release or administrative release procedures could be looked at. And I think that we're all circling around I would go to all nonviolent felonies with exceptions for domestic violence and perhaps persistent failures to appear. This is pretty much the policy that the San Joaquin County District Attorney requires of its prosecutors. They go all
YOLO, Mike, sorry.
Excuse me, Yolo County. So Yolo County District Attorney Ryan Cousins, who spoke before us yesterday, and he discussed their mandatory, it's a mandatory policy for all nonviolent felonies with some exceptions are administrative release. And those exceptions are persistence, failures to appear. What are some of the other ones, Tom?
The sentence that's going to be more than 8 years, or those are the ones that stuck out to me as the most relevant.
Now, some of that can be done in the field by a cop, and some of that would require some calculation, for example, the sentence piece. But I think that can be done administratively, and would cover a large portion of all arrests. All right. So putting that aside, do we want to skip the whole? So that does leave some cases, which are admittedly the minority of cases, violent felonies and primarily violent felonies. Do we want to suggest a statewide bail schedule, or should every county continue to make up its own bail schedule? Or do we just not touch this?
Yeah, maybe not touch it.
I would say one of the two, either
Yeah.
let counties continue to set bail because it's geographically focused. I mean, and one of the witnesses brought it up yesterday. I don't remember who, but what might be reasonable in one county is not reasonable in another. So either we leave it alone, or we, I don't know.
Is Judicial Counsel tasked with making sure that there's some consistency between bail schedules, Tom, or no?
No, there's no oversight. Though a few things that might help the discussion here. First is the Judicial Council does set a statewide schedule for offenses in the vehicle code. So there is that precedent. And bail schedules, though I think they get their greatest use in this pre-arraignment period that you're talking about, Mike. The judges, when you go to court, they still are the starting point. I think we heard that yesterday. In fact, there are rules about when a court can go below the bail schedule for violent offenses. So I think they're still relevant even after arraignment and you go to court. And the third thing I think to throw into the mix too is, and you mentioned this yesterday, Mike, is that in San Francisco and Sacramento County, federal courts have found that the pre-arraignment bail schedules are unconstitutional because they don't account for ability to pay. So that I think there's a lot of uncertainty about both what's the right policy and how legal is what's happening in that pre-arraignment period. But that's not the only time bail schedules are used. So I think it's important to keep all that in mind, that even if they don't seem like something that makes sense maybe for their pre-arraignment period, they still are going to be used in court when the judge does weigh in. But that gets us to some of the Humphrey recommendations too, and when the court should even start thinking about cash bail. So all these things do bleed together a little bit.
So Mike, maybe because these things are intertwined, maybe we should go through all the slides before we set on what, because we may want to connect a few in terms of the proposals. So maybe we should have you or have staff present them to us before we land on, and then we can think about, all right, we want this in this context, or we want to combine these two, or.
All right, let me run through the slides quickly, and then we'll go sort of backwards. We'll go back over them. So you're right, the bail schedule, our conversation just now particularly bled into the cite and release or administrative release. The other proposal that we have on this slide that we talked a little bit about yesterday was that allow courts or maybe perhaps require courts in some, if not all instances, to be to offer the bail themselves, so you don't have to pay a private outside bail bondsman. So in other words, you could either have partially secured bonds, meaning you pay a percentage up front, but you get that back, like unlike with the bail bonds, you don't get it back, or it could be completely unsecured and say that if you don't return to court, then you owe $10,000, but you don't have to pay anything up front. Same financial incentive to return to court, it's just whether or not you pay up front or you pay at the back end. And that could be done by the court and avoid a lot of the problems that we've heard about bail. Next slide. This is what we were just talking about expanding cite and release or administrative release, I think might be a better term because it gets a little bit complicated. I think the Yolo County District Attorney's policy is a good starting point here, which is all nonviolent felonies with exceptions that Tom discussed. Next slide. All right, this is the most complicated piece and probably the meat of our recommendation. This is about implementing Humphrey. As we heard yesterday, Humphrey was decided with a lot of great fanfare and hope and optimism, and it has, if anything, made things worse and more confused. It certainly has not achieved its promise. So I think I think across the board, there's desire for some kind of codification of its holdings, or at least some codification of what exactly should be happened at arraignment in compliance with Humphrey. And here are the bullet points that we discussed yesterday. There's a built-in presumption, it's not explicit, but in Humphrey that there's a presumption of release, right? Maintaining the presumption of innocence, obviously, before conviction. This is a square holding from Humphrey is cash bail can only be considered after non-financial conditions and the standard and the set for ability to pay. That the court has to decide what ability to pay is. There's nowhere in Humphrey or elsewhere, what does ability to pay mean? How much? What percentage of your income, your net worth? Can you borrow from other people? There's nothing in that. As Tom mentioned, there's departures from the bail schedule. We also heard about standards for electronic monitoring, which are mentioned in Humphrey's. We also discussed a little bit yesterday, there was some idea that the burden of proof here should be on the prosecution, meaning that it's you should be released unless the prosecution can prove that you're either a danger to public safety or a flight risk. And then the reasons I think should be put on the record by the judge as to why pretrial restrictions are being put in place. The other, I believe that the detention standard is also touched upon in Humphrey. So this is the next bolded round bullet point, is that there's nowhere in the penal code, and this is part of the conflict between section 12 and section 28 in the Constitution that we heard about yesterday. But there's no place that says, okay, the court thinks that you're a danger to public safety, right? There's no definition of what danger to public safety means. There's no standard of, is it proof beyond a reasonable doubt? Is it clear and convincing evidence? There's nothing in the penal code or elsewhere that says this has to be put on the record. There's no, can this apply to every arrest, all felony arrests, all serious violent offenses? There's no procedure spelled out in code as to how that determination should be made. Instead, what I believe is happening in a vast majority of cases is that excessive bail is being set, money bail, as a proxy. So the courts don't need to go through this detention evaluation, which is unclear, and instead saying your bond is $1 million and I'm just worried that, so this is to get transparency into the system and saying, if you're really worried about somebody absconding or a threat to public safety, you have to say that on the record and you have to have a certain standard. I think that that's important. And then the next thing that in implementing Humphrey or arraignment reform, let's call it, is the time when an arraignment should happen. And the proposal from the staff is to have that at 48 hours without the exception of Sundays and holidays. Sooner would be even better, but it would require a major, and we heard in, New Jersey and other states, they do it within 24 hours. I would love to get there, but it seems like a super heavy lift for our system at this point. Next slide. And this is the last slide. We talked about, should there be a probable cause determination? At what point this would be codifying Riverside versus McLaughlin. And then we also talked briefly, is whether or not the bail rules should extend to parole and PRCS violations. So these are people who are arrested for violations of their parole. Currently, there are no rules that apply to that. And should those be extended to those people as well? So those are the proposals. Maybe we go back to that. Yes, Senator Skinner.
I want to go back to, before we go into each of the proposals, sort of what reflection on yesterday and what struck me the most. I have so far, because there have been many bills in the legislature around the whole issue of cash bail. Most of my thinking on it, and never quite as much a deep dive as we've been going into, but has been around this whole issue of cash bail. But what I heard yesterday was a very startling statistic about the impact of just being jailed, that independent of the charge, of whether it's going to, if that charge is going to stick, just the fact of being in custody for, and I forget what time period they said, you just even like 48 hour, had a huge predictive impact on that person's then
it's a cascade of negative consequences.
Yes. And so hearing that, it really struck me that I'm sort of feeling like, okay, what are we trying to correct for? What are the most serious consequences of our structure as currently designed? And it seemed like that was a very serious consequence. And that just changing bail, and maybe that is the administrative release issue, but just changing bail does not address that. And if we go to your last slide that showed, some changes around the timing of arraignment, you would still be in custody potentially for, 48 hours. So I wonder how we could, first off, I wonder what other impressions anyone else had from what we heard of what are some core things that we should be trying to correct for. And then secondarily, what we might do to affect that issue.
Well, I was impressed with the statistics they gave us from New Jersey and New York. And they've vastly reduced the jail population, right up front, which I think is really the whole key to remedying, the bail situation with people staying in custody for months. At the same time, I think I don't know what the delay, how long people remain in custody, whether it's 12 hours or 24 hours. So I was just astounded by how their system has achieved results that really address your concern about prolonged detention pre-trial.
I share that, and I think our conversation, and Senator Skinner, I think you honed in on it right away, actually, is it seems like, and Tom, correct me if I'm wrong, that New York and New Jersey have an expanded administrative release, site release practice. Is that correct?
Yeah, I think so. It's a sort of delegated release where it's not just the judge who's making decisions. So you don't have to have all the apparatus of going to court and counsel and all that, which you're able to make things go much quicker. So I think that's why the idea is you want to, people who are going to get out on their own recognizance or minimal conditions, you want to do that as quickly as you can and save the court for the folks who, it's given the nature of the offense, are probably not likely to get out quickly anyway. So how do you sort of do that filtering quickly is I agree, is the key issue. And that's, I think, where the the administrative release or delegated release authority is really important. And that's a lot of what SB 10 tried to do. It had timetables and rules and all that. And everyone under that was going to be evaluated within 24 hours. And based on that, a lot of people would have been released and do that filtering to get people to come to court. But Prop 25, ruled otherwise on that issue.
But correct me if I'm wrong, New Jersey and New York are not doing a whole evaluation for many of the site, let's call it site and release or administrative release. It's more like the Yolo County, where it's just like, what are you charged with? What is your sentence exposure? And without any evaluation, because it's a nonviolent charge and you haven't absconded a million times previously, then you just don't get bail regardless.
I think it's a mix, and we'll definitely get more. But what I recall Chief Justice Rabner saying was that, now that the process has been around for a while, that police officers are kind of anticipating what's going to happen and exercising their discretion more, whether that's in their law or sort of a sign of the system kind of working. I'm not sure, but I think it's a mix. I think it's and I think that's always how it's going to have to be, because, however many counties we have that times 10 police departments. So to get uniformity in that practice is, I think, very challenging.
Tom, on that point of you were describing what was in SB 10, and of course now we know because the proposition, but could we get some analysis before we completely lock our proposals of what parts, like if we wanted to go back to some portion of that, what we are not to prohibit? What does the referendum on SB 10, what leeway do we still have for enacting some portions of it? Or, ways to enact comparable or similar without running into the direct problem of that referendum?
That's the $10 million question, pun intended, of what is permissible after a referendum. There's 2 lines in a California Supreme Court decision and no real decisions after. So, and I think there would be legal challenges no matter what. But
yes, but there's certainly it would be benefit from some analysis on, what at least might have the best chance of surviving a legal challenge.
Yes, I think we can try to figure that out best we can. But my first response would be that expansion of the cite and release and the sort of delegated authority in the hands of police officers, that wasn't addressed by SB 10 at all. So I think that would be a pretty clear area, which is I think one reason why it's worth discussing.
Okay. But the attraction beyond the benefit to the individuals of some of that is I think our justices, we have so much burden on our courts now, and we're so backlogged. And with the economy going in the direction it's going, we're going to have a hard time increasing budgetary allocations to, say, assist our courts for doing much of this. And if we can reduce pressure on the courts, that's a benefit in addition to the benefit that towards whatever proposals we adopt around how it benefits the individual.
But also, just on the finance piece, we keeping people out of jail, I know it doesn't go to the courts.
Oh yes, that's a huge, jail is a big cost.
Right.
And a lot of the bad conditions in jail are due to the overcrowding and.
Precisely. So it seems like that there's not a ton of enthusiasm for a statewide bail schedule, but more interest.
I want to preface that I'm not opposed to a statewide bail schedule. I just think it needs a lot of conditions. So it needs those other parts to be part of it, so that and it needs the accommodation for the differing median or average incomes in our different parts of the state.
So let me just make sure I understand your concerns, because I think I share them. When you say it needs the other elements, you're talking more.
That it only applies to, say, we didn't put this, we didn't specify here, but is it only applying to, say, the serious felonies, violent felonies, or is it only applying to, what's it applying to?
Sure, and you're referring there to as opposed to the administrative release or cite and release.
Or another, yeah.
Yeah, whatever we're having to be calling it. So, right, I've been just thinking of those as two separate ideas, but perhaps they're the same. But I think either way, I think that there is obviously some interest here in developing a cite and release or administrative release expansion or explanation current rules. Because right now it's extraordinarily it's limited, number one, and then it's very discretionary. So, like I said, I keep on going back to the Yolo County DA's plan, which is not very discretionary at all. It has a very set sequence of rules about where they apply. So I would support that. I would also, in addition, say for the remaining cases, which are going to be violent felonies and people who are held for other reasons, that there be a statewide bail schedule. And I think that we do need to work out, it has to be tied, and it should be sent to Judicial Counsel to figure out with considerations like county median income as a benchmark.
Yeah, I think the range idea is a good one. You had plenty of latitude there in terms of a statewide bail schedule. But I think what I'm hearing is that that these two things, the administrative release and the bail schedule, go hand in hand, and you don't get the bail until you've already complied with whatever instructions or mandates we've given with respect to the presumptions, et cetera, et cetera. Then you get to bail. And then, one observation I would make on the bail schedule, I'm sure it's probably already taken into account as one of the factors justifying, a higher bail, regardless of ability to pay, is, particularly in the northern counties and even down here, you get some pretty big drug cases. And I'm sure some reference is made to the amount of weight or quantity of drugs that are seized. And certainly there, although you might argue that's not directly a crime of violence, or even, I guess it would come under public safety, but certainly enhancements for weight in terms of setting the bail schedule, I think would be called for. Regardless,
there's a bail schedule, which is automatic, and then a judge at arraignment, 48 hours, can increase or decrease the number.
Right, there's a ton of marijuana or kilos of cocaine or something.
Sure. Okay, so for immediate purposes, I'm going to say that we certainly support, or we are going to make a recommendation to set better rules and expand the practice of administrative release or cite and release, or however we want to describe it.
I think administrative release is the right term.
All right, administrative release. And that is actually more accurate, because some cases will be very automatic and a police officer could make that determination by themselves. But some, for example, if your sentence exposure is 10 years or more, that will require a little bit of computer analysis. It's not a discretionary decision, but it just requires a little bit more research, booking, et cetera. But it could be done pretty quickly. And we might be able to put some timetables on that. I'm hearing that there is also some support in conjunction with that on bail schedule for the remaining cases, maybe a range for Judicial Counsel to determine. Moving on to the next bullet point, unless anybody has anything to say about what we just discussed. Judge Henderson, we haven't heard from you. I'm just assuming that you think we're.
Yeah, I've been listening and I agree with the flow of the discussion. I'm inclined to say that I assume I was very struck by the judge's testimony about their great fear of being voted out of office. And I'm assuming that whatever we do here, we're assuming that there's nothing we can really legislate about that fear. So lurking behind anything we do is going to be a judge's, some judge's decision that, well, I know what this says, and I know we talk about assuming success and 80%, 90%, but I'm not going to take the chance, and I'm going to not release this person. And I'm assuming this is what one of the things that I came away with yesterday, and was talking with my friends all night last night in a get-together. That's a huge elephant in this room we're discussing, I think, and I don't know what we can do about it.
The way that I took that, and I was a little, it was difficult for me that people, but it's human nature, right? That people are concerned about their jobs, but because they're concerned about their jobs, they're keeping people behind bars, which is, really horrible calculus. But what I think the judges were asking for, without saying it directly, was that they want more mandates from the legislature. So that they can say, should the horrible event happen, I had no choice, here's what the law says. And that the more discretion that we provide to courts, which makes sense for individualized determinations, the more political pressure that they feel, because then the decision was theirs, as opposed to requirements from the legislature. So it does include a balance, and we'll talk about this with Humphrey. Right now, it's wide open. So I understand this particular pressure. Like, nobody understands how to interpret Humphrey. So I do think that that legislative help direction would be welcomed by all parties. My preference, and I think responding to the judges, would make it mandatory in many instances. So judges won't like that their hands are tied in the one instance. On the other instance, it gives them, the cover that they say that they are concerned about.
I just want to add, I was very, I appreciated that they expressed that, because I think it was important to put the elephant that we knew is in the room. And it's an elephant in the room for legislators too. So I wonder, Judge Henderson, whether any of your colleagues or your friends that you spoke to last night, did they have any suggestions? I mean, the tricky part, on the one hand, discretion is very important, because trying to cross every T and dot every I, you can never anticipate all the different nuances. On the other hand, or rather, if we also try to make it very explicit, what the conditions are without discretion, the legislature's tendency is going to be to be more restrictive, and for the same reasons that the judges are concerned. So how we get out of that conundrum, I don't know, but I wondered if they had any suggestions in your conversation you had with them.
They didn't. They really didn't, and I was looking for them, and this was a very bright group of people, people who have clerked for the Supreme Court justices and are judges themselves, and we didn't come up with any I didn't come up away with any suggestions from him. That's what I was looking for. I'm sorry.
Do you think, here's a question I have for that. I hear this loud and clear. Do you think, Judge Henderson or Senator Skinner, it seems some people have suggested some very clear principles to be announced that are, for example, the presumption of innocence must continue throughout the bail proceedings until conviction, right? That would seem like pretty uncontroversial for the legislature to pass. And to the judges, do you think that would have any impact on their bail determination? All these people are sitting there saying, well, he probably did it, and I'm worried that he did it. But if there was a clean statement from the legislature that says the presumption of innocence must be retained through arraignment until conviction, and as part of the bail consideration, does that change anybody's behavior, or is that just an empty platitude?
I think it just certainly doesn't hurt. I don't see any danger in it. Well, may help.
Yeah, I've heard that argument dozens of times in the closing argument by the defense.
Yeah,
I think it's more like a platitude, and I don't think putting it in a statute is going to make any difference in terms of the judges making bail decisions.
Right,
yeah.
that's what we're talking about, obviously.
Yeah.
I think it's a difficult one, and this committee's favorite word where we try to thread this needle is, we could all say it together, presumptions, right? Where the legislature is trying to put its thumb on the scale. On the other hand, giving some latitude for individualized determinations in the courts. It's in some ways a middle ground, or I think what we talk on the Humphrey slide, one other thing that will be helpful is forcing courts to put on the record why they think this person is a flight risk, why they think they're a danger. I think that will have some marginal impact. And it's also another reason, by trying to focus again on the administrative release idea, is to make it as mandatory as possible. And these should be, I think, should be relatively easy for the legislature. Perhaps I'm wrong, Senator Skinner. Nonviolent felonies, without danger, without lots of prior arrests, no pending cases, no repeated failures to appear in the past, no DUIs, no domestic violences. I think for those crimes, it should be administrative release. And with the experience of New York and New Jersey, hopefully that is enough. Right now, we have way too much discretion in the system going down to police officers, which I think is not helpful. All right. What about this idea about, I like it a lot. I brought it up several times, but it maybe didn't grab everybody's attention, is to have the courts be essentially the bail bonds persons. This is in order to try to avoid some of the problems with money bail. And I think I was particularly struck with the idea that we're extracting money from poor people. You have to pay 10% of an arbitrary number and you never get it back, even if you do everything that you said you're going to do, right? That's how the private bail bonds industry works. Instead, in some states, the court can say, you give us 10%, or you give us 5%, or you give us 0% upfront. But you still have the financial incentive. It maintains that idea of a financial incentive to return to court. Whether or not that's a legitimate incentive or not, we won't get into here. But it just seems like a good option. And we could say it in a very non-mandatory way. Courts may offer this. They already have fines and fees departments, collection agencies. I mean, they already have some infrastructure to deal with this kind of with money, basically. I would make it more mandatory. I think it's a promising idea, but perhaps there isn't an interest in it.
Yeah, I mean, I think it's a good idea. I always wondered why we didn't have it. I don't know what the feds do. My recollection is that it's basically a promissory note. I don't even think they get collateral. But I think it bears, I wasn't aware that it was already permitted under state court to receive a deposit. So I wonder if there would be any opposition by the courts or the Judicial Council to taking on that increased responsibility. The other thing that I was, I guess, not surprised by was from the bail agents, that there's a lot of uncollected, promissory notes and judgments out there. I wonder if that's something that, the counties really want to get into, becoming collection agencies. Any unpaid balances above and beyond the deposit.
Let me just say a couple things about that, because that really irritated me, I have to say. First of all, their bail agencies aren't paying the bails anyway to the courts, right? We heard that from the insurance commissioner. So the courts are not getting the money even from when the bail agencies are doing it. Number two, it sort of puts the lie to the idea that financial incentives are in any way a good idea to get people to return to court. And number three, courts are already involved in collection agencies all the time,
Mhm.
even for just parking tickets. So yes, this is $10,000 is a lot more than your average parking ticket, but I'm sure that they, are familiar with trying at least to collect money. And it's not a zero administrative cost. I get that. But I think it does avoid a lot of the really problematic pieces of money bail.
Yeah. No, I mean, I like it in principle.
Yeah, me too. And you're
Judge
the-
Henderson, do you know how it works in the federal bail system?
No, I don't. That's why I'm being reluctant here. I have no experience with the federal bail system, so this is a whole new area for me to consider, and I'm being, staying to the background and listening to those of you who've had greater experience in the state system.
Yeah. Yeah, because when it comes to the district court judge, all that has been taken care of in the magistrate court.
Right, exactly.
All those things. So you never get involved in that.
Never, yeah, I've just never had the issue come before me. And you're to be congratulated, from my view, Mike, with the equanimity with which you listened to that testimony or that comment yesterday. You're very graceful.
Well, listen, I really do appreciate that everybody showed up, and we do want to hear the comments from the bail bonds industry.
Yeah.
And I have to say that I was impressed. Here's the thing. People can get out quicker with private bail. There's no way that a court system, even the best system, is going to work as quickly as a private industry and getting people out of prison. And for a lot of people, we heard that is critical. Now, it does value finances, and people have to pay through the nose for it, and a lot of very negative consequences, but it's better in many cases than the alternative.
What is the likelihood, if you were to redirect this bail money or 10% or whatever, or something less, through the courts, with creating an infrastructure through the courts, through that very money, that would satisfy the judges, wouldn't add a burden to people, would add new people to take care of this and do a better job? Is that unrealistic?
I don't know if it's unrealistic, and I want to get to you, Judge Espinoza. I mean, part of the idea, though, is to not extract money from people if they show up for, this is the only purpose of bail. Like, let's remember, the only purpose is to give an incentive for people to return to court, innocent people to return to court.
Right.
If we're going to charge them a lot of money to administer it's like asking them to pay for electronic monitoring. It's the exact same thing.
Yeah, that's true. Yeah.
And we should do it for free if we think it's an incentive, just like we do electronic monitoring for free. We offer that as a free service.
Mhm.
Judge Espinoza, I'm saying that somewhat ironically. Judge Espinoza?
Well, I'll just take a slightly contrary position. If you are going to make the court the pass-through agency for the 10%, you might incentivize them for creating a structure by allowing them to keep 1 or 2% when it's all said and done to pay for the cost of creating this infrastructure. But, I just don't know how I feel about the court being the bail agent.
My instinct is that the courts should the state should pay for the administrative costs, just like the states pay for the ankle monitoring bracelets. Same exact thing to me. If we think this is a legitimate reason to incentivize people to come back to court. Now, if the state doesn't want to take that on, and we'd rather have private bail industry, I think that that's fine. I think that at least an option for counties that want to do this. Tom and/or Joy or Rick, do courts have the authority to do this now? California?
No, they can take the full bond amount. So, if bail is set at 50,000, they can take the full 50,000, but they can't take a portion or order it unsecured and with the promissory note.
Okay.
It seems like partly a whole structure that would be expensive to set up, but because I don't I mean, other than courts administering like fines and fees, is there anything analogous that the courts already do that would make this not so difficult to set up?
Seems very analogous to fines and fees for me. I mean, can't restitution fines and fees be tens of thousands of dollars? I mean, it's still big money. Rick, maybe you can weigh in on the fines and fees. I mean, we're still talking about the state collecting or the county courts collecting large amounts of money.
I agree with you, Mike, that it's very analogous to that type of situation where, you know, courts are regularly placing people on the hook for large sums of money. And also what comes to mind is sometimes, you know, diversion or plea agreements where people say, hey, if you fail, then you have to pay this amount of money. If you don't, or if you aren't successful, you know, in those situations, people aren't signing a promissory note, but I think courts are certainly in the business of collecting debt. So I don't think that it would be that much different.
I think we need to hear from a court administrator on this.
All right, well, we can do a little research on that, and we can certainly, I mean, I think at minimum, right, allowing courts, county courts to experiment with this, saying that they may do this, I don't see any harm in that. All right, let's chew on this a little bit more. Next slide. This is, I think we already discussed this. This is to expand the idea of administrative release to make it, my preference, and we can circulate it, would be to, at least as a starting point, use the Yolo County District Attorney guidance there. Next slide. All right, this is Humphrey and arraignment procedures. Okay, this is, like I said at the outset, there seems to be a demand from all sides to do something about, I'll call it implementation of Humphrey, or improve the arraignment procedures. And this should not run afoul of Prop 25. And in fact, it's probably mandated by Humphrey, which is not being carried out in the courts. And I think this is, in some ways, should be non-controversial in that it's restating some of the holdings of Humphrey's. Cash bail can only be ordered after considering all of the non-financial conditions. That's in Humphrey. I think this is not in Humphrey, but it makes perfect sense in that we set standards for ability to pay. What does ability to pay mean? Is it ability to pay the whole $100,000? Is it ability to pay the 10% to the bail bondsman? Is it based on income? Is it based on net worth? Is it based on family resources? There's ability to pay in other portions of the penal code. I think that we just adopt those similar standards.
Right. And I'm sure that exists. Ability to pay has been around a long time.
Well,
Go ahead, Tom.
so two thoughts. Humphrey says reasonably afford. So it's not just ability to pay, it's you can afford it and reasonably afford it. So I think that's a good starting point, actually. Like, it has to be reasonably afford. It's not you have to empty your bank account and your family, and if you even have bank accounts in the first place. And on the point of other ability to pay standards in the penal code, they are so general. I think they actually don't provide a lot of help for us. They say, you know, you consider the defendant's assets and their anticipated assets no more than 6 months in the future, and anything else relevant. It's a standard that is almost not entirely helpful. And I think the issues you raised, Mike, given the particular intersection here with the bail industry, would want to explicitly address all that. And I think that's the problem, is there's really nothing in the penal code that's very analogous to it that actually addresses this tricky area a little bit. But we do have that reasonably afford language from Humphrey, which I think is could be very fruitful to expand on that a little bit.
So Tom, are you in other words suggesting that we say that you recommending that the legislature say reasonably afford means X% of your annual income?
Something like that. I think this is another area where we can look at other states that have done reform, and I don't think it'll be very complicated. And I'll also point out this was part of a bill, SB 262, that had ability to pay standards in it that were removed before it was, as it progressed. But we can also look to that a little bit, perhaps.
Okay. Does anybody have any thoughts on this ability to pay standards? I mean, does everybody agree that some standards should be set?
I agree it should be said. And I think I'm thinking more about the people at the bottom of the pay scale here. Depending on how you word it and how it's interpreted, you're really going to be, for some people at the very lowest ends, talking about their ability to feed their kids and clothe them and do certain things because they may have a paycheck, which makes them get by day to day, and they'll have an ability to pay, but it's going to affect the quality of their own living. I just throw that out, that I think that ought to be a consideration in talking about their ability to pay.
I agree wholeheartedly, and I, putting the thumb on the word reasonably afford.
Yeah.
I think that has to be considered. And again, keeping in mind the presumption that these people are innocent, right? These are pre-conviction.
Right.
In the civil courts, there is a fee waiver process for indigent folks to apply to have their fees waived, which could be, I think we should look at that as a model for how we get this information to the court, ability to pay information to the court. So
Right.
it's a form, couple pages, has all of the information that Judge Henderson just referred to and is concerned about. Size of your family, amount of your income, your rent, et cetera. And fees are automatically waived for certain folks, like if you're an SSI recipient, if you're receiving aid for your children, that sort of thing.
And there's also those standards that I think federal government sets, on twice the poverty level, whatever, that is to be regarded.
Okay. Yeah.
I think that, so we all agree that's.
Well, I want to just on that one, that is obviously a process that exists now, but I was carrying the legislation to and tried in the budget to eliminate many of the fines and fees because of finding that it's that a lot of the folks who are eligible for that process were not filling out those forms, and they were not being made available to them, and the knowledge was not there, and also the time it took. So while it's a process that exists, it's not it hasn't proven to be that efficient or that utilized.
Well, right now, we're not doing anything, right? So I think that we do need to at least set some standards. And Tom, maybe we look to what some of the advocates or what we're doing either throughout California or elsewhere on how do we set a reasonable ability to pay, knowing that it's going to be very imperfect.
Yeah.
But it's a constitutional mandate. Courts have to do it.
Yeah.
And I think the legislature should say, here's how you do it. And everybody acknowledges it's imperfect, but we can't keep on holding people because they're poor, period. Or we have to do our best job.
And I'm sorry, I think on those access issues you mentioned, Senator Skinner, the one way we might be able to address that is everybody will have a lawyer to, advocate for the ability to pay here in a way that isn't always the case in other contexts. That's not perfect either, but I think it is a unique aspect of this too. If there's rules in the penal code, that makes it a lot easier for the parties to know what to fight about
Yeah.
a little bit.
Well, this is slightly off topic, but it bears on some of the things we're trying to weigh here. But I was struck by the Yolo County's DA's comment that, sort of that on this issue of we have a good way of determining who's at risk of not coming back. And he basically said, hey, if there's someone who has already not returned to court and we have this data, then, obviously we're going to do bail for them. And it occurred to me, I wondered that a good number, well, I don't know a good number, rather some number of people who don't show up to court are those folks with either homeless and or mental health problems. And how, now maybe our care courts that's being established will help with this, but I thought they're in no better ability to pay. And, it just reminded me of this circumstance of how our jails so much, our courts and our jails are the place where we deal with mental illness, where it really is not very appropriate. And certainly a person without the cognizance to be able to know when to come back or even know what day it is not necessarily someone who, anyway, it just struck me, and I don't know how we accommodate any of that in the different proposals we're designing.
Yeah, I was struck by that too, and I think that those are good points. One thing that he did, he sort of got caught up on, because I reread the bail instructions from Yolo County this morning, and they talk about willful failure to appear, right? Which is what the criminal statute is, but also in the bail context, that's what really should count against you if there's willful failure to appear, which I know doesn't address the bigger problems of mental illness and addiction and all that with regard to the jail systems. But I think that seems like the right. It also does show you that like money bail is not a terrific incentive to begin with, right? If they've absconded 10 times before and money hasn't helped in the past, like why would money help now? But put that aside.
Right.
I think that the willful, multiple, and whatever the multiple number should be, but this gets to the cite and release. This is an exception to the administrative release, right? Basically, they say nonviolent felony, but if you've absconded 10 times before, then you're not eligible for cite and release, because we want to have some assurance that you're going to come back to court. And I think that whatever the number is, but some number of willful failures to appear makes sense as a some limitation on trying to make sure that people come back to court, with emphasis on the willful piece.
And I also think on the mental health part, I mean, Humphrey doesn't address that, but there's no reason the statute couldn't have some, like in the court should consider the mental health condition and how that would impact, past non-compliance of court orders and things like that. That seems like it'd be an appropriate thing to make explicit, because why not? And it's something that, committee has always taken those issues into account with a lot of the other recommendations you all have made.
I think that makes sense. Moving to the next bullet. So I think that there's agreement on that we should set a standard for ability to pay. How exactly those standards should be set is difficult, but I think not impossible. Right now in California, there are restrictions on departures from the bail schedule. So these are primarily people who are we're at arraignment, they haven't made bail, or they're being held for a violent felony. And there's restrictions on departing downward from the bail schedule, but I don't think restrictions for departing upward from the bail schedule. To me, that should be the same, right? If a judge thinks the bail schedule is too high, they should be able to lower it. Maybe that goes into the ability to pay calculus. And if they think it's too low, they should also be able to raise it. It doesn't seem like that there should be different standards.
Yeah, that sounds fair.
And as Judge Cousins pointed out, that seems to be in direct conflict with what Humphrey said. So it might be unconstitutional in a way too, because it puts tight restrictions on this individualized ability to pay determination that the court said the equal protection requires. So there's lots of reasons to address that.
The next bullet, and I don't know how much we want to dig into this, is one common and increasingly used tactic that courts use to ensure compliance with returning to court are electronic monitors. We heard some testimony about the detrimental effects of electronic monitoring. I don't know if we want to wade into this. Do people want to wade into that? It's used in obviously many different contexts, not just in the pretrial release context, but we could set, this would be an appropriate place to set standards saying something to the effect of can't interfere with employment and medical care and other things like that. And no more than absolutely necessary, and kind of a last resort, sort of like money. It could be treated in some ways like financial bail. I don't know how if people were impacted by the testimony about electronic monitoring. Okay, maybe that's a issue that we'll table for the time being. I think that Judge Cousins, if I'm correct, suggested this, that it should be clear that if you're going to hold somebody in prison pending trial, the burden should be on the prosecution to establish that they're a flight risk or danger to public safety. That should be explicit. Shouldn't be on the judge to figure it out. Shouldn't be on the defendant to prove that they're not a flight risk. That needs to be done by the prosecution.
Yeah.
Okay. And furthermore, that the reasons should be put on the record. Reasons that you're imposing bail restrictions and finding these things needs to be said by judge, and that the only reasons to hold somebody are for flight risk or danger to public safety.
Mhm.
Okay. Related, next bolded bullet point. There's nothing in the penal code that says, let's say judge wants to hold somebody, but they believes that they're a danger to public safety. That's the reason why they want. It's not that they're not concerned that they're not going to show up. They're concerned that they're a danger to public safety. There's no standard in the penal code. Again, there's a standard set, an ambiguous one in section 12 of the Constitution. But I think that the penal code should have a very direct standard that prosecution has to prove danger to public safety. Danger to public safety means, I would use what we've used in the past, unreasonable risk to commit a violent crime, and by clear and convincing evidence. I'm just throwing that out.
Well, I'll just refer back to my hypothetical on large quantity of narcotics. You may have someone who's a mule, no ability to pay, but obviously someone is backing him with a lot of money.
This would be to hold without money, regardless. I'm holding you no matter if you put up $1 billion. I'm finding you to be a risk because you're dangerous.
Yeah,
This
I mean,
is
I
a
think
pure
drugs are-
detention, regardless of money, no money.
yeah. Well, anyway, I think drugs are a public safety issue.
So
Large-
risk to commit a new
large-
drug crime, risk to commit a new.
Well, Mike,
ahead,
I
Tom.
think we'd want to follow what's in section 12 here to avoid possible constitutional issues. So there it's supposed to be limited to risk, I think, of causing great bodily harm to another person, which is going to overlap a lot with, I think, the violent offenses you mentioned, or if there's a threat to you've made a threat to a person, it seems, very likely you're going to carry it out. But I think expanding detention beyond what's in Article 12 could cause some problems.
Okay, so Article 12, I agree. Article 12 says that it's a risk to cause great bodily harm to somebody, which again does not define what potential crime they might commit, but that makes sense, and it could be a big drug cartel issue. Doesn't set the standard, so I think a standard should burden on the prosecution. I think we all agree with that. Clear and convincing evidence seems the right standard to me. So far, that's in compliance with 12. 12 only applies to crimes of violence. Is that right, Tom?
Yes, but the way it defines that is not
Right.
by referring to the list of violent offenses for strikes. It says felony offenses involving acts of violence on another person. So it doesn't just say violent offenses as in penal code, whatever. It has its a bespoke definition to a degree. And I think that's one of the issues that the courts are currently working out. But I think it's broader than just a list of violent offenses at first blush. Maybe that's something that the penal code could build in, if it's a violent offense on the list that's in the penal code, that's probably a starting place, and maybe in some other circumstances where the offense involve acts of violence against another person. Section 12, it's specific about some things, medium specific about other things, and just doesn't address other things. So I think filling in some of those gaps might be the right approach here. To sort of start with that is what's there, and then what needs to be filled in might be the best way to approach it.
I think that's right, and I think that we can work on that. Here's the more difficult policy question, I think, for this committee goes unspoken in Section 12. Section 12 appears to say that if you, and correct me if I'm wrong, Tom, if it's not one of these crimes of violence against another person, meaning it's a non-violent crime, then you cannot be held because you're a danger to public safety. The only reason why somebody can be held is only because that they're a flight risk.
I think that last point is a little unsettled. That's one of the things that Judge Cousins has said is an open question after Humphrey a little bit. If you're just talking about flight risk, how extreme can the court go in preventing release? But certainly you can't be held for public safety reasons under Section 12 unless it's one of the specified categories that we're talking about.
All right, should we make that explicit?
I think that would make sense.
Non-serious, non-violent crime for which, and no danger to, however, of violence, you cannot be held on preventative detention. Meaning no bail, no money, no amount can do.
Question. So I was struck by, I think it was Yolo County who DA referenced stalking as being one of the areas that they didn't
Consider violent, yeah.
right, didn't hold people. And I thought to myself, well, if it were the domestic violence, not that the person had yet committed it, but if that was the concern, then such stalking is whatever. Anyway, it's one of those tricky things where we don't want to be creating more reasons to hold people, but then stalkers, I don't know what the data is around stalkers and later violence, but.
So, there's a number of, so I think when that came up yesterday was in the context of the administrative release. So they would exclude those people from automatically being released. And then that puts the decision to the court, where the court can consider all the different conditions short of preventative detention, ankle monitor, stay away order, protective orders, which are going to be of limited value perhaps, but there's a lot the court can consider. And then I think if none of that's appropriate, Section 12 does allow, this is where the threat to another person might come in for very extreme cases like that, where it says if there's clear and convincing evidence that the person has threatened someone with great bodily harm and a substantial likelihood the person would carry out the threat if released, our Constitution would allow detention in that circumstance as well. But there's hopefully a lot of other interventions the court could do that would work before getting there. But in those extreme cases, it would seem to be permissible.
Okay. Seems like regardless of a detention standard should be set in the penal code, and we should clarify Section 12 there.
Yeah, and I'll just to add a little bit more color to this. I mean, we in doing our research for this, we were given transcripts by courts saying, now under Humphrey, I can detain anyone I want, or Humphrey only applies to nonviolent cases. So, hundreds of these decisions are happening a day. I'm sure you can find extreme transcripts for any issue we look at, but it did seem to be like there really was. It's not just that Humphrey didn't have an effect, that actually may have caused a lot of confusion in a bad way about a lot of these issues. So that's why the legislature and the penal code sort of following what's in the Constitution and making it clear, I think would be very helpful and important here.
Yeah, I heard loud and clear from everybody that Humphrey is not working as everybody had hoped, as anybody had hoped.
Right.
All right, the last bullet point on this list is right now, the rule on you have to have an arraignment basically as quickly as possible, but not later than 48 hours with exceptions. The exceptions are Sundays and holidays. Do we want to eliminate those exceptions to just say it has to be 48 hours, even if it's on a Sunday, even if it's on Christmas morning, because it's the 48th hour?
I think it should be 48 hours without exception.
All right, you know what, they're just all gonna say it costs money, Senator.
Yes, but if they're not detained, then that costs less money.
Okay.
You know, this would work, I think, and we'll talk about this in a little bit, our potential recommendation around assignment of counsel. So this would be an arraignment where you'd have a lawyer who had sufficient time to provide meaningful representation. So I think that helps me understand this one a little bit. It's not sort of nothing happens for 48 hours. It's along the way you will have gotten an attorney who can start getting things together to make the appropriate arguments at that arraignment and bail determination.
All right. So to summarize, well, does anybody have any other thoughts about the 48 hours? I mean, it really should be 24 hours, but I think that's asking that's too heavy a lift right now for the court system in California. All right.
And a lot of places are doing it quicker too. I mean, we shouldn't, there's just, as always, there's a lot of variation. So this wouldn't necessarily, it's not going to affect every county the same way.
Got it. So again, cash bail only after considering non-financial conditions. This is sort of in, and as Judge Cousins said, this is all kind of reinforcing the presumption of innocence and indeed the presumption of release. Setting a standard for ability to pay, removing restrictions on departures from the bail schedule. We're going to skip the electronic monitoring for the time being. Burden of proof is on the prosecution and the reasons need to be stated on the record. In addition, create a detention standard that's in compliance with Humphrey and Section 12, and eliminate the exceptions to the 48-hour rule.
Easy.
Moving on. All right, we heard these are the two last sort of miscellaneous items. It sounds like there's not a probable cause review of warrantless arrests as required by Riverside versus McLaughlin. How could we easily correct this, Tom?
You could add one line to Penal Code Section 825 and say the court must conduct a review of probable cause within, as promptly as possible, within 48 hours. And it can be on paper, which means counsel doesn't have to be there. It's, you know, it's really, it's a safety valve for very extreme cases where there is no reason to have arrested someone in the first place. It's the most protective of the presumption of innocence of anything we've talked about today. And just the irony is this arose from a case in California 3 decades ago, and it was a 1983 case where someone was suing the county for money. So if they were to bring these cases again today, there'd be no qualified immunity or anything, and counties would, I don't know, might face some serious liability. So there's, it just should be in the penal code. It's a rule that's required, and it's just totally not addressed. And I think places do it, some places don't do it promptly. There's no record made, and just that should be part of what happens in every case. As we've been told it needs to be by the United States Supreme Court.
Any thoughts?
I think that one's a legitimate, that's a good one to include in our recommendations.
It certainly fits within our mandate as the committee is to clarify and make the penal code more smooth and easier to understand and implement. My only thought about it is I'm not convinced that this will result in changes in people's cases, in very many people's cases, one way or another.
That's probably correct, but the cases where it does are cases where there's no reason to have arrested the person in the first place. So it's, you know, it's
Sure.
it's worth affecting those small number of cases.
All right. And the last issue is,
Oh, I'm sorry, Mike. And I think part of this too is clarifying that this also applies in the juvenile context. As Sue Burrell told us yesterday, the California Supreme Court has said you get even more time for when a kid is arrested, when it seems like it should be the opposite. This should happen even quicker in those contexts. I think just putting that in the law is very important as well.
Agreed. All right, the next issue is around, so these are people who are on or post-conviction. They've been convicted and they've been sentenced to parole or PRCS, which is post-release community supervision, which is operated by the probation departments. Sometimes it's in lieu incarceration, sometimes it's at the end of their incarceration, it's a tail at the end of their incarceration. There are currently, as I understand it, no rules, none of these bail rules that we've discussed. Or their ability to pay, can you pay for bail any event, or their detention when you're being arrested in this context for violating terms of your parole or PRCS. Did I tee up the question properly, Tom?
Yeah, exactly. You know, we've talked a lot about the presumption of innocence, but when you're post-conviction, that framework doesn't apply. And I think what happens a lot of the time is the person is held without bail, even if the alleged violation is a technical one. And there was a law passed last year. That's what AB 1228 is, which was by Assembly Member Lee. Basically saying if you're arrested on a probation violation, you're going to be treated like anyone else who's arrested, and there's a presumption for release. But of course, the court could hold you if there's appropriate reasons to do so. So the idea is to treat everyone on community supervision, so parole, PRCS, split sentences, in that same way, where instead of defaulting to a presumption of holding someone for an unspecified period of time, the default is for release, but the court would have the discretion to hold if it was appropriate.
Well, you're not going to get these cases. You'll get them within a couple of days usually, because there's a hold, and so it's not an extended amount of time that they're in custody. As you point out, there's no presumption of innocence. It's an open case, and they've been sentenced. So I think that I'm surprised that the statute would say that the same presumptions would apply to them, even if it's a technical violation. That's for the court to determine when they come into court in custody. And many times, if there's a new case, both are resolved. If there is no new case, it's generally handled pretty expeditiously. A warning, time served for the violation, and they're out. So anyway, this is LA, and they come in. They've been in custody maybe 2 or 3 days on the warrant, on the violation.
What I heard from a few folks, particularly around this, and when we were looking into probation issues more generally, is that sometimes that expeditious part doesn't happen. I don't believe there's any time limit in the penal code for how quickly a court needs to resolve something. So, and I think that's something that would be appropriate for a court to take into account. Like, I will resolve this in 2 days, so I'm not gonna whatever. But Judge Espinosa, I don't know if you have any experience of this or any thoughts.
Well, I mean, my experience is similar to that of Justice Moreno. These cases usually come in attached to some new filing, or if it's a technical violation, it comes in and gets resolved pretty quickly. So, I don't know.
Yeah, and I may be mistaken, but I think some have bailed out on the PV, and then they come in out of custody. So maybe bail is set.
I've not seen that, but in fact, many times it's a no bail hold because it's post judgment.
Yeah. And sometimes it's more than just one PV. It's like 2 or 3. So.
The last thing I'll say, this was also something that the detention work group that the Chief Justice put together. It was part of one of their recommendations, and they did a pretty deep survey statewide, I think. Yeah. So, but yeah, we didn't hear too much about this yesterday. That's for sure.
I mean, if the Chief Justice Committee has looked at this, I don't see any reason to disagree with whatever their findings were. I'm just telling you based on my experience.
Right.
I agree.
I think this one might need to require a little bit more
Mhm.
thought.
Yeah.
I'm particularly curious about how many cases we think this affects. Is this a huge issue? Is this a marginal issue? I think especially for technical violations, it makes a ton of sense to have a good timetable to make sure the cases are heard quickly. For new allegations, it's a lot more complicated.
Right.
Um,
And I think 9 out of 10 times, it's a new case. Not a, failure to report to the probation officer. I don't think you would see one of those at all. It'd be a new case that would come to court. Then you pull the PV file.
Hmm.
Mike, are we going to take a 5-minute break right now? I've got a call I got to make.
Yes, we are going to take a break. Does anybody have it seems like this issue is kind of, we don't know enough about this to make a recommendation.
Well, I'm just going to fall back on the Chief Justice's work group.
Yeah.
And if this is their recommendation, who are we necessarily to disagree with them?
Yeah.
We're not in a position to disagree, but I'm not going to just rubber stamp everything that they said without.
No, I know. Okay.
And to that point, the legislature can Tom, we can see your screen.
Oh, sorry.
It's all right. Just because the legislature is just as welcome to take up their recommendations as they are to take up our recommendations.
Okay.
Perhaps it's a way that we can note it in our report as something that, sort of came up, but is not, sufficiently studied. I feel behind the curve on this. Senator Skinner?
Well, it's, I like Justice Espinosa's point that we can't assume what data they were reviewing when they made the recommendation, but I would imagine they would have access to the data that we raised the question of. So I think it is worth it to ask them some questions regarding their, what data they reviewed, because if it addresses, say, what you raised, then I think it would be a good recommendation potentially for us to include. But I think we have to look at what, see when their working group prepared it, is there some background in?
Yeah. We can say
Okay.
we reviewed that and we agree or we disagree.
Fair enough. Let's get some more information on. And in fact, I think it would be helpful, Tom, perhaps not now because Justice Moreno has to take a break and we should all take a 10-minute break. But to what extent our recommendations are consistent with or in conflict with the recommendations from the Chief Justice's working group?
I think they're extremely consistent. Let me offer that high level picture.
Well, good.
Yeah.
I think that we should be very explicit about that.
Mhm.
All right. So this concludes our conversation about bail and pretrial issues and arraignment that we had yesterday. I think that we have some enough guidance from the committee on honing recommendations from staff that will appear in more detail in our next meeting. And then let's take a break now until 11:45. And when we get back, Tom will go through the recommendations from our prior meetings to make sure we're all on the same page about that as the committee begins to prepare our formal recommendations, which are coming quite soon. And we need to make decisions fast because our recommendation, the staff needs time to prepare those recommendations. And with that said, let's reconvene at 11:45.